Welcome to HKA Talks 2. Today we are joined by Robert Wheal, who is a partner in the Dispute Resolution Group at White & Case in London. His practice focuses on both international arbitration and commercial litigation. Robert, welcome to HKA Talks 2.
Well, welcome and thank you very much for inviting me. I'm delighted to be here. Just by way of background, I've been a disputes partner at White & Case for about 13 years now. And in that time, I spent my time working in mainly international arbitration in the infrastructure area, a lot of power plant disputes, construction disputes relating to oil and gas facilities, and then gravitating from that also into the oil and gas disputes proper. So I've been, initially I did a lot of work in the Middle East, and lastly, I've been involved in a lot of our work in Africa and in trying to grow our disputes practice there.
Robert, I presume that you and your team have been involved in some remote hearings by now. So I'm just curious to understand what experiences you've had from working in that format.
Yes, we have. In fact, some of my colleagues were engaged in an in-person hearing just as the lockdown hit, and they swiftly had to relocate to their own jurisdictions and resume the hearing, not obviously in person, but virtually. And despite some trepidation, their experience was very positive, and they found that it worked well, and that with a lot of common sense, they could overcome many of the initial hurdles. One thing we found in particular was it was important not to try to replicate exactly what you would do in an in-person hearing in a virtual hearing. They are different mediums, and you need to respond differently. We also found that how much more tiring it is to be a part of a virtual hearing, whereas you can sit long court days for 6 or 7 hours quite easily. A virtual hearing seems to have a natural 4 or 5 hours limit, and that's all people can take staring at a screen.
Yeah,
it's interesting they had that direct correlation. I think many people have had that experience where you're in the midst of an in-person hearing and then you're having to transition to a virtual one, and I guess it's everyone is trying to adjust at the same time, and the tribunal getting used to the kind of the different style of advocacy as well. So that's interesting take.
And I think also one of the other things we saw is that initially when the lockdown happened, the instinctive reaction to many things was to try and postpone them.
Yeah.
And so there was a lot of cases, and I'm sure HKA has seen this with expert appointments as well. A lot of cases got moved back because people thought this is the only way we can deal with the lockdown. Whereas actually now there is more of a willingness to go ahead and to have virtual hearings and to use that. And also we found things like interim applications, things like that. They work perfectly on a virtual basis, and it may well be that when we return to whatever normal is, we will end up using the technology a lot more. I think it's quite an exciting opportunity for arbitration.
No, absolutely, and just kind of picking up on that point even further still, it'll be very interesting to have been involved, especially in respect of how the witnesses dealt with the situation, because I don't know whether you're on witnesses of fact or witnesses of opinion, but of course, the impacts or the implications on expert evidence or witness evidence presumably is going to be quite significant through that kind of format. So I just wonder how the pacing change and how that was dealt with the team. It seems like quite an interesting point.
It is. I mean, I think there are a lot of, lawyers are suspicious people, and there's a lot of concerns about how you make sure that when a witness is in a room and you can't have another person present because of lockdown restrictions or whatever, you can't be sure they're not being coached, they don't have access to other documents or notes or things like that. That may be less of a worry with professional experts, where their professional integrity probably gets you a lot of the way there. But we certainly had to deal with some protocols for that, making sure that everyone was happy that the room set up, the number of cameras, you could be confident what was going on. I think it also changes the style of advocacy slightly. People find that probably a more analytical approach is better, whereas the more dominant style that you see in the TV courtrooms doesn't work quite so well virtually. And the other thing I've certainly seen, and this is more in the context of interim applications where I've been looking for the response of the tribunals, it's much harder to gauge people's mood virtually. I mean, you're staring at the screen, you can see the faces, but you don't somehow that you lose something on the body language side. So it is difficult to replicate it and judge it, but I think these are all things we can overcome. And it works well with things like expert determinations and that sort of thing, where there is perhaps more natural discipline. One of the problems about any virtual program or hearing, I should say, is that you have to have a certain discipline that people can't talk over one another. And that changes the dynamic as well. So I think for things which are slightly more structured, like an expert determination or something like that, the process works very well. And we have yesterday we had a hearing with experts from all over the world participating very well, and of course we saved a lot of airfares. Yes. It brings its challenges with coordination. One of the hardest challenges, I think, in a lot of this is it's very difficult to get notes to your team. I mean, most of the software allows you to send emails, but you're not quite sure who you're sending it to and whether you trust it. Whereas in the good old days, a post-it note or a tug on the back of the gown, if you're in court, worked quite well. So it technology is there, but there are some things that just being in person with your team is much easier to coordinate and run with.
So just to finish that point, so do you think there'll be a complete return to kind of life as normal after all the restrictions are lifted in respect of hearings, or do you think there'll be some aspects of the remote hearings? Of course, we've all seen elements of it up to the point pre-COVID in any way, but do you think that there'll be more of that going forwards?
I incline to the latter view. I think there are those who will say, "Oh, we'll go back entirely." I'm not sure we will. There are cost savings for short hearings, interim applications. I think everyone has been forced to use the technology and has found that it's pretty good. So I don't see us turning back to that. And I think also perhaps the days when people would just do audio only hearings may have gone because the technology is so good. There are challenges with doing whole cases, document heavy cases or witness heavy cases, I think, virtually, but they're not insurmountable. And there are some interesting sort of hybrid ideas where other dispute centres are getting together so that, if you have a group of people near a dispute centre in, say, Lagos, they can use the facilities in that dispute centre and join a hearing that's going on in the IDRC in London or vice versa. So you bring some of the equality of technology that may be a disadvantage at the moment. You bring some of that together by using dispute centres as hubs to have virtual hearings. And so there's a lot to be said. And I think it'll be a moving space. But I do think, in the same way that I think attitudes to working from home will have changed dramatically because it's been forced on us, virtual hearings are going to change the landscape to a degree, but they will never quite replace the benefit of being in person with your colleagues.
Face to face. Yeah, no, that's a good point. Valid point. Thank you.
So I guess just expanding on the international reach that your practice on Whiting Case as a firm has. Have you seen different jurisdictions reacting different ways to the pandemic? And if so, can you sort of elaborate on those?
Just taking that from a dispute side, on the litigation side, I think different jurisdictions have responded in their own individual way to the challenges of virtual hearings and to dealing with this. And so the UK courts have been pretty good. They've tended to use Skype for Business to have commercial hearings go ahead. Other jurisdictions, some of the civil law countries have also done that. The American system has had some cases going on. On the international arbitration side, I think the institutions have done pretty well. And so we've seen the LCIA, the ICC, the Singapore Centre, those sorts of centres carrying on functioning, working remotely. Obviously, I think those parts of the world which are ahead of us in the recovery cycle, they are more close to being back to normal now. But I think they have managed to show that you can do these things perfectly well remotely. Arbitration has the benefit that a lot of it could be done remotely before. I mean, most filings were done electronically before. You could start arbitration proceedings by emailing your filings or uploading your filings to the arbitral centre or to however you do it. So arbitration was well placed for the pandemic, and I think has had it's pretty willing to embrace the challenge and go with it. So I think the international arbitration community has done well and is well placed to carry on in the new normal.
Yeah, no, that's interesting. So moving on to something slightly different. I mean, we're all aware that the current global situation has a huge financial impact on our clients, on contractors and employers alike. On that basis, do you think clients, in respect of a dispute, will look at alternative ways to finance disputes? So if so, do you see this as a way to protect their cash position in the immediate term, or a way to expedite proceedings, maybe to release cash early, or do you see it as a combination of both, perhaps?
I think it's probably, again, a bit of a combination. I mean, when I did my first funded case back in 2012 or so, there were only a handful of funders you could go to. It was very much funding a one-off case, and the market was quite small. I mean, now I was seeing that Burford says it has an investment portfolio of about 3 billion in funded cases. And so I think, the market has changed, and litigation or third-party funding is definitely there and is part of a tool set of any international disputes lawyer. I think still there is going to be a degree of wariness. When White & Case did its arbitration surveys, it's typically found that there has been a little bit of suspicion among people who haven't used third-party funding about how it works, and that tends to actually be eroded when they get into contact with third-party funders and they become more familiar with it. But I think it's still going to be relatively few people who will monetize their awards and who will go into the portfolio funding that some people offer. But I think for a lot of people who are cash strapped and facing financial difficulties in bringing claims and have meritorious claims, the attraction of going to a funder and getting that cash flow benefit will be considerable. So I see more litigation funding happening.
Yeah, I guess one of the points will be how many of those cases are sufficiently strong and without enforcement issues that they're actually able to be funded, and that's always been a slight difficulty for funders. Is there's normally a fairly small pool of cases that pass the necessary thresholds for their risk appetite.
I think that's absolutely right. And funders have always been wary of the construction case because they find it too fact heavy, too many experts. The problem with the sophisticated experts is that it makes it that they don't necessarily have the in-house ability to judge who's right and who's wrong, or it may be more nuanced than that binary view. But I think if you are if you have possibly an investment treaty arbitration case, I mean, you may be in the mining sectors, you maybe your construction site or whatever opportunity has been expropriated, or you've suffered, unfair or unequal treatment, and you can bring your case as an international treaty arbitration. That has always been something that funders do like, and so we may see a lot more cases in that space.
Yeah, and I think there seems to have actually been an increased appetite in construction funding as well. For funders over the last couple of years, definitely historically it was an area, as you say, that they were very reluctant to invest in. And I think there's been some sort of fairly hefty shifts in the market that have now kind of that now opened that up. Well,
and it's so ripe for finding funding solutions because the disputes are big, the amounts of money at stake are large. There must be ways of doing it, and I think, as you say, some of the funders are increasingly willing to look at it, and if they can find ways of making it work, it will have a big change because it's a very attractive pool of cases if you can find a funding model that works for it.
Yeah, absolutely. So I guess looking ahead. And using our crystal ball to sort of imagine a world post COVID-19 and coming out of lockdown. Do you think there will be any permanent changes to how either the legal construction arbitration community operates? Essentially, what are the positive lessons that can be taken away from this kind of forced situation that we found ourselves in?
I think actually most of the firms, certainly the big firms, will have found that they can work remotely very well. I know certainly we were lucky at White and Case in that we had good technology to fall back upon. And in the arbitration group, we were used to trying to work remotely from a hotel in Dubai or Lagos or somewhere, and so it's working from your dining room isn't quite so daunting, even if you do have more children running around than is normal. But I think we are going to find the legal market will have changed. I think we've talked about the use of virtual hearings. I think that will change and will have a lasting legacy. But I still think, like so many industries, things are based on human, contact, and that actually going to see people, going to see a site, changes your view. However many times you may have looked at a video or photographs of the site, until you've seen a construction site in person and walked out some of the bits and seen what the argument is, it doesn't become real. And I'm sure all lawyers who've done construction arbitration will have experience of, until you go and ask someone for documents, you don't always get those documents. You have to be there and you have to chase down the documents, not because of any malfeasance, but just because people don't realize what you need to do your job. Mm-hmm. So I think although some things will have changed, I think the way we work will have changed, I think other things will stay the same, and there'll still be a value for when we can get back out there on site to meeting with our clients, seeing projects, and restoring ourselves to some of the old practices we had.
And do you think there will be a shift in the type of disputes, that the ones that you were typically dealing with pre-COVID to what you'll be looking at in the short to medium term?
I mean, at the moment, a lot of our caseload is, as you say, existing cases where COVID has no role to play. But in terms of going forward, I think there'll obviously be a lot of projects where there have been force majeure notices served. And it'll be very interesting to see how people pick up the pieces, and after that, see how the records were, whether actually force majeure is the true cause of delay, or is in fact a convenient cloak for something that was going wrong beforehand. So I think there'll be a lot of cases there. I have some of my colleagues are doing some research on disputes boards and whether actually they think there'll be a growth in the number of disputes boards, because that has some advantages for bringing it speedy, quick determination of disputes, or relatively speedy, quick determination of disputes, as long as they don't go off into a large arbitration immediately afterwards. And so it may be interesting to see whether there's an uptick in that, and so their research will be interesting. But fundamentally, I think the other thing, and you've touched on it, is that there's obviously there may well be a recession, or is likely to be a recession. Costs are tight. If you work anything to do with the oil and gas industry, apart from COVID, you've got the oil price that has dropped considerably. And whenever there's that sort of pressure on the whole sort of industry, you tend to get more disputes. So I think there will be challenging times ahead.
I imagine there'll be lots of issues coming from the flow of cash, if nothing else. Frankly, as cash reserves dry up, then the cash flow stops and the supply chain starts shouting, so to say.
I think that's absolutely right, and we saw that before, back in the the financial crash. Pressure on the supply chain, people trying to pass on bad news down the chain, that sort of thing, and that produces a lot of disputes. And if there isn't enough liquidity, you'll get some failures, which will also put pressure on the supply chain.
Yeah, I think that's a big problem.